Hey friends, Casey Ashmore back in the studio. Thanks for joining me on this a little bit less formal, or attempting to be less formal, deep dive into criminal defense and the presumption of innocence. It's hard to be informal regarding this because when somebody's liberty is on the line, it's one of short of life. There's a little else that is more treasured by each and every one of us individual human beings than the right to be free. And this is a country of many freedoms and bounty of gifts, but it's also a country of laws, and laws that can be strictly enforced and harshly at times. But there's a reason why criminal defendants are given this gift to protect their liberty, this gift of the presumption of innocence. And it's because it comes out of a very twisted, knotted up, centuries long, convoluted way of putting people on trial and having them either have to have their body perform some miracle, or survive some traumatic event, or survive battle by combat. And if they didn't, burned at the stake, drowned, horrible disfigurement and death, or poisoning. These are not effective ways to get at the merits and the truth of what's going on when someone's been accused of a crime. And it wasn't until the 13th century that that the notion that a person is presumed innocent unless proven guilty was first really articulated, written, and then after that became part of the growing process of what eventually became law in the Western world. And again, it's not a new concept. It existed further back than the Roman Empire, and at least as early as ancient Babylonia, and somehow got lost in the dark ages of medieval Europe. And then about the time of the Renaissance, this notion started to come back. And of course, there was the Magna Carta that gave certain rights, recognized the rights of certain royals, and took away some of the rights of the absolute power of the British Crown. And then ultimately our own revolution here in the United States of America, which started to recognize and put into writing many of the rights that had been created through what was then the British common law, and the chief of which was the presumption of innocence. Because our earliest forms of government here in the United States of America, the Continental Congress and the body of laws that came out of that before the United States of America was formally formed, and the Constitution of the United States of America and the Bill of Rights were ratified, still had this notion that the presumption of innocence must be there to protect citizens against the unfairness of what was perceived of the government, the British Empire, their unfair trial practices against the citizenry of the colonies, later to become the United States of America. So it's as fundamental and as far-reaching as the early 1600s, and certainly became part of the fabric of our nation's justice system when we first broke away from the British Empire in the late 1700s. Anyway, more on the presumption of innocence next in this video series. Please like, subscribe, and share. Leave me a question or comment. Again, what we're doing here is a deep dive into the importance of and the foundations of the presumption of innocence, how long it's been a part of our culture, why it's part of our culture, and how important it is. And then, of course, the outcomes when the presumption of innocence is maintained, and a finding that someone is not guilty beyond a reasonable doubt, and then the consequences of a finding of guilt. Thanks again for watching. Please like, subscribe, and share. More to come on presumptions of innocence in the practice.